Citizens Rulebook, a palladium of liberty. Where the Spirit of the Lord is, there is liberty. 2 Corinthians chapter 3, verse 17. Bill of Rights, Jury Handbook, the fireworks are in the document itself. Read the Constitution. Lincoln said, "Study the Constitution. Let it be preached from the pulpit, proclaimed in legislators, and enforced in courts of justice." Rights come from God, not the state. You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by human laws, rights derived from the great legislator of the universe, John Adams, second President of the United States. Table of Contents. Section 1. A Handbook for Jurors. Jury Duty, page 2. You are above the law, page 4. Jury Rights, page 6. Law of the Land, page 7. 10 Commandments, page 8. Communist Manifesto, page 8. Give up rights, page 9. Jury tampering, page 11. Section 2. Give me liberty. Patrick Henry Schacht, page 15. Jury of Peers, page 16. Freedom for William Penn, page 18. Jefferson's Warning, page 20. Section 3. Original Documents. Index to the Documents, page 21. The Declaration of Independence, original title, page 26. The Constitution, page 32. The Bill of Rights, page 49. Section 1. A Handbook for Jurors. Quote, that this nation, under God, shall have a new birth of freedom. Abraham Lincoln. Jury Duty. The purpose of this booklet is to revive, as Jefferson put it, the ancient principles. It is not designed to promote lawlessness or a return to the jungle. The ancient principles refer to the 10 commandments of the common law. The common law is, in simple terms, just plain common sense and has its roots in the 10 commandments. In 1776, we came out of bondage with faith, understanding, and courage. Even against great odds and much bloodshed, we battled our way to achieve liberty. Liberty is that delicate area between the force of government and free will of man. Liberty brings freedom of choice to work, to trade, to go and live wherever one wishes. It leads to abundance. Abundance, if made an end in itself, will result in complacency, which leads to apathy. Apathy is the let George do it philosophy. This always brings dependence. For a period of time, dependents are often not aware they are dependent. They delude themselves by thinking that they are still free. We never had it so good. We can still vote, can't we? Eventually, abundance diminishes and dependency becomes known by its true nature, bondage. There are a few ways out of bondage. Bloodshed and war often result, but our founding fathers learned of a better way. Realizing that a creator is always above and greater than that which he creates, they established a 3-vote system by which an informed citizenry can control those acting in the name of government. To be a good master, you must always remember the true pecking order or chain of command in this nation. 1. God created man. 2. Man, in parentheses, that's you, created the Constitution. 3. Constitution created government. 4. Government created corporations, etc. The base of power was to remain in we the people, but unfortunately, it was lost to those leaders acting in the name of government, such as politicians, bureaucrats, judges, lawyers, etc. As a result, America began to function like a democracy instead of a republic. A democracy is dangerous because it is a one-vote system as opposed to a republic, which is a three-vote system. 3 votes to check tyranny, not just one. American citizens have not been informed of their other 2 votes. Our first vote is at the polls on election day when we pick those who are to represent us in the seats of government. But what can be done if those elected officials just don't perform as promised or expected? Well, the second 2 votes are the most effective means by which the common people of any nation on earth have ever had in controlling those appointed to serve them in government. The second vote comes when you serve on a grand jury. Before anyone can be brought to trial for a capital or infamous crime by those acting in the name of government, permission must be obtained from people serving on the grand jury. The Minneapolis Star and Tribune, in March 27, 1987 edition noted a purpose of the grand jury this way: a grand jury's purpose is to protect the public from an overzealous prosecutor. The third is the most powerful vote. This is when you are acting as a jury member during a courtroom trial. At this point, the buck stops with you. It is in this setting that the juror has more power than the president, all of Congress, and all of the judges combined. Congress can legislate, in parentheses, make law. The president or some other bureaucrat can make an order or issue regulations. And judges may instruct or make a decision, but no juror can ever be punished for voting not guilty. Any juror can, with impunity, choose to disregard the instructions of any judge or attorney in rendering his vote. If only one juror should vote not guilty for any reason, there is no conviction and no punishment at the end of the trial. Thus, those acting in the name of government must come before the common man to get permission to enforce a law. You are above the law. As a juror in a trial setting, when it comes to your individual vote of innocent or guilty, you truly are answerable only to God Almighty. The First Amendment to the Constitution was born out of this great concept. However, judges of today refuse to inform jurors of their rights. The Minneapolis Star and Tribune, in a newspaper article appearing in its November 30th, 1984 edition, entitled, "What Judges Don't Tell the Juries," stated, quote, "At the time of the adoption of the Constitution, the jury's role as defense against political oppression was unquestioned in American jurisprudence. This nation survived until the 1850s, when prosecutions under the Fugitive Slave Act were largely unsuccessful because juries refused to convict. Then judges began to erode the institution of free juries, leading to the absurd compromise that is the current state of the law. While our courts uniformly state juries have the power to return a verdict of not guilty whatever the facts, they routinely tell the jurors the opposite. Further, the courts will not allow the defendants of their counsel to inform the jurors of their true power. A lawyer who made Hamilton's argument would face professional discipline and charges of contempt of court. By what logic should juries have the power to acquit a defendant but no right to know about that power? The court decisions that have suppressed the notion of jury nullification cannot resolve this paradox. More than logic has suffered. As originally conceived, juries were to be a kind of safety valve, a way to soften the bureaucratic rigidity of the judicial system by introducing the common sense of the community. If they are to function effectively as the conscience of the community, jurors must be told that they have the power and the right to say no to a prosecution in order to achieve a greater good. To cut jurors off from this information is to undermine one of our most important institutions, Perhaps the community should educate itself. Then citizens' call for jury duty could teach the judges a needed lesson in civics. This booklet is designed to bring to your attention one important way our nation's founders provided to ensure that you, in parentheses, not the growing army of politicians, judges, lawyers, and bureaucrats, rule this nation. It will focus on the true power you possess as a juror, how you got it, and why you have it, and remind you of the basis on which you must decide not only the facts placed in evidence, but also the validity or applicability of every law, rule, regulation, ordinance, or institution given by any man seated as a judge or attorney when you serve as a juror. One juror can stop tyranny with a not guilty vote. He can nullify bad law in any case by hanging the jury. I am only one, but I am one. I cannot do everything, but I can do something. What I can do, I should do, and with the help of God, I will do. Everett Hale. The only power the judge has over the jury is their ignorance. We, the people, must relearn a desperately needed lesson in civics. The truth of this question has been answered by many testimonies and historical events. Consider the following. Jury rights. Quote, the jury has a right to judge both the law as well as the fact in controversy. John Jay, First Chief Justice, U.S. Supreme Court, 1789. Quote, the jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796, signer of the unanimous Declaration of Independence. Quote, the jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court Justice, 1902. Quote, the law itself is on trial quite as much as the cause which it is to be decided. Harlan F. Stone, 12th Chief Justice, U.S. Supreme Court, 1941. Quote, the pages of history shine on instances of the jury's exercise of its prerogative to disregard instructions of the judge. U.S. v. Daughtry, 473 F. 2ND 1113-1139, 1792. Law of the land. The general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land, and any statute, to be valid, must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. Quote, all laws which are repugnant to the Constitution are null and void. Marbury v. Madison, 5 U.S. in parentheses 2, Cranch, 137, 174, 176, 1803. Quote, where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436 P. 491. Quote, an unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton v. Shelby County, 118 U.S. 425 P. 442. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date the decision so branding it. Quote, no one is bound to obey an unconstitutional law, and no courts are bound to enforce it. 16 American Jurisprudence, 2nd edition, section 177, late 2nd edition, section 256. A summary of the Ten Commandments. The Ten Commandments represent God's government over man. God commands us for our own good to give up wrongs and not rights. His system always results in liberty and freedom. The Constitution and the Bill of Rights are built on this foundation, which provides for punitive justice. It is not until one damages another's person or property that he can be punished. The Marxist system leads to bondage, and God's system leads to liberty. Read very carefully. 1. Thou shalt have no other gods before me. 2. Thou shalt not make unto thee any graven image. 3. Thou shalt not take the name of the Lord thy God in vain. 4. Remember the Sabbath to keep it holy. 5. Honor thy father and mother. 6. Thou shalt not murder. 7. Thou shalt not commit adultery. 8. Thou shalt not steal. 9. Thou shalt not bear false witness. 10. Thou shalt not covet. Directly above the Chief Justice's chair is a tablet signifying the Ten Commandments. When the Speaker of the House in the U.S. Congress looks up, his eyes look into the face of Moses. The Bible is the book upon which this republic rests. Andrew Jackson, 7th President of the United States. Quote, the moral principles and precepts contained in the Scriptures ought to form the basis of all civil constitutions and laws. All the miseries and evils which men suffer from vice, crime, ambition, injustice, oppression, slavery, and war proceed from their despising or neglecting the precepts contained in the Bible. Noah Webster. A summary of the Communist Manifesto. The Communist Manifesto represents a misguided philosophy which teaches the citizens to give up their rights for the sake of the common good, but it always ends in a police state. This is called preventative justice. Control is the key concept. Read carefully. 1. Abolition of private property. 2. Heavy progressive income tax. 3. Abolition of all rights of inheritance. 4. Confiscation of property of all immigrants and rebels. 5. Central bank. 6. Government control of communications and transportation. 7. Government ownership of factories and agriculture. 8. Government control of labor. 9. Corporate farms, regional planning. 10. Government control of education. Give up rights for the common good? Where the people fear the government, you have tyranny. Where the government fears the people, you have liberty. Politicians, bureaucrats, and especially judges would have you believe that too much freedom will result in chaos. Therefore, we should gladly give up some of our rights for the good of the community. In other words, people acting in the name of government say we need more laws and more jurors to enforce these laws, even if we have to give up some rights in the process. They believe the more laws we have, the more control, thus a better society. This theory may sound good on paper, and apparently many of our leaders think this way, as evidenced by the thousands of new laws that are added to the books each year in this country. But no matter how cleverly this Marxist argument is made, the hard fact is that whenever you give up a right, you lose a free choice. This adds another control. Control's real name is bondage. The logical conclusion would be, if giving up some rights produces a better society, then by giving up all rights, we could produce the perfect society. We could chain everybody to a tree for a lack of trust. This may prevent a crime, but it would destroy privacy, which is the heartbeat of freedom. It would also destroy trust, which is the foundation for dignity. Rather than giving up rights, we should be giving up wrongs. The opposite of control is not chaos. More laws do not make less criminals. We must give up wrongs, not rights, for a better society. William Pitt of the British House of Commons once proclaimed, quote, "Necessity is the plea for every infringement of human liberty. It is the argument of tyrants. It is the creed of slaves." Inalienable, in parentheses, unalienable, or natural rights. Natural rights are those rights such as life, in parentheses from conception, liberty, and the pursuit of happiness, e.g., freedom of religion, speech, learning, travel, self-defense, etc. Hence, laws and statutes which violate natural rights, though they have the color of law, are not law but impostors. The U.S. Constitution was written to protect these natural rights from being tampered with by legislators. Further, our forefathers also wisely knew that the U.S. Constitution would be utterly worthless to restrain government legislators unless it was clearly understood that the people had the right to compel the government to keep within the constitutional limits. In a jury trial, the real judges are the jurors. Surprisingly, judges are actually just referees, bound by the Constitution. Lysander Spooner wrote as follows, quote, "Government is established for the protection of the weak against the strong. This is the principle, if not the sole motive for the establishment of all legitimate government. It is only the weaker party that lose their liberties. When a government becomes oppressive, the stronger party and all governments are free by virtue of their superior strength. They never oppress themselves. Legislation is the work of this stronger party, and if, in addition to the sole power of legislation, they have the sole power of determining what legislation shall be enforced, they have all power in their hands, and the weaker party are the subjects of an absolute government. Unless the weaker party have a veto, they have no power whatever in the government and no liberties. The trial by jury is the only institution that gives the weaker party any veto upon the power of the stronger. Consequently, it is the only institution that gives them any effective voice in the government, or any guarantee against oppression." Essay on the trial by jury. Jury tampering? A jury's rights, powers, and duties. The charge to the jury in the first jury trial before the Supreme Court of the U.S. illustrates the true power of the jury. In the February term of 1794, the Supreme Court conducted a jury trial and said, quote, "It is presumed that the juries are the best judges of the facts. It is, on the other hand, presumed that the courts are the best judges of law. But still both objects are within your power of decision. You have a right to take upon yourselves to judge of both, and determine the law as well as the fact in controversy." In parentheses, State of Georgia versus Brailsford, ETAL 3 DALL period 1. Quote, "The jury has an unreviewable and unreversible power to acquit in disregard of the instructions of the law given by trial judge. U.S. vs. Daughtry, 473 F. 2ND 1113 1139, 1972. Hence, jury disregard of the limited and generally conviction-orientated evidence presented for its consideration, and jury disregard for what the trial judge wants them to believe is the controlling law in any particular case, in parentheses, sometimes referred to as jury lawlessness, is not something to be scrupulously avoided, but rather encouraged. Witness the following quotation from the eminent legal authority above mentioned. Quote, "Jury lawlessness is the greatest corrective of law in its actual administration. The will of the state at large imposed on a reluctant community. The will of a majority imposed on a vigorous and determined minority. Find the same obstacle in the local jury that formerly confronted kings and ministers. Daughtry, cited above, note 32, at 1130. Supreme is not capitalized in the Constitution. However, behavior is. Article 3. Jury lawlessness means willingness to nullify bad law. The right of the jury to be told of its power. Almost every jury in the land is falsely instructed by the judge when it is told it must accept as the law that which is given to them by the court, and that the jury can decide only the facts of the case. This is to destroy the purpose of a common law jury, and to permit the imposition of tyranny upon a people. There is nothing more terrifying than ignorance in action. Goethe. Engraved on a plaque at the Naval War College. Quote, to embarrass justice by a multiplicity of laws, or to hazard it by confidence in judges, are the opposite rocks on which all civil institutions have been wrecked. Johnson, engraved in Minnesota State Capitol, outside the Supreme Court chambers. Quote, the letter killeth, but the Spirit giveth life. 2 Corinthians chapter 3, verse 6. Quote, it is error alone which needs the support of government. Truth can stand by itself. Thomas Jefferson. The jury's options are by no means limited to the choices presented to it in the courtroom. The jury gets its understanding as to the arrangements in the legal system from more than one voice. There is the formal communication from the judge. There is the informal communication from the total culture, literature, current common, conversation, and of course, history and tradition. Daughtry, cited above at 1135. Laws, facts, and evidence. Without the power to decide what facts, law, and evidence are applicable, juries cannot be a protection to the accused. If people acting in the name of government are permitted by jurors to dictate any law whatsoever, they can also unfairly dictate what evidence is admissible or inadmissible, and thereby prevent the whole truth from being considered. Thus, if government can manipulate and control both the law and evidence, the issue of fact becomes virtually irrelevant. In reality, true justice would be denied, leaving us with a trial by government and not a trial by jury. How does tyranny begin? Why are there so many laws? Heroes are men of glory who are so honored because of some heroic deed. People often, out of gratitude, yield allegiance to them. Honor and allegiance are nice words for power. Power and allegiance can only be held rightfully by trust as a result of continued character. When people acting in the name of government violate ethics, they break trust with we the people. The natural result is for we the people to pull back power, in parentheses, honor and allegiance. The loss of power creates fear for those losing the power. Fearing the loss of power, people acting in the name of government often seek to regain or at least hold their power. Hence, to legitimize their quest for control, laws and force are often instituted. Unchecked power is the foundation of tyranny. It is the juror's duty to use the jury room as a vehicle to stem the tide of oppression and tyranny, to prevent bloodshed by peacefully removing power from those who have abused it. The jury is the primary vehicle for the peaceable restoration of liberty, power, and honor to we the people. Your vote counts. Your vote of not guilty must be respected by all other members of the jury. It is the right and the duty of a juror to never, never, never yield his or her sacred vote. For you are not there as a fool, merely to agree with the majority, but as an officer of the court and a qualified judge in your own right. Regardless of the pressures or abuse that may be heaped on you by any other members of the jury, with whom you may in good conscience disagree, you can await the reading of the verdict, secure in the knowledge you have voted your own conscience and convictions, and not those of someone else. You are not a rubber stamp. By what logic do we send our youth to battle tyranny on foreign soil while we refuse to do so in our courts? Did you know that many of the planks of the Communist Manifesto are now represented by law in the U.S.? How is it possible for Americans to denounce communism and practice it simultaneously? The jury judges the spirit, motive, and intent of both the law and the accused, whereas the prosecutor only represents the letter of the law. Therein lies the opportunity for the accomplishment of liberty and justice for all. If you and numerous other jurors throughout the state and nation begin and continue to bring in verdicts of not guilty in such cases where a man-made statute is defective or oppressive, these statutes will become as ineffective as if they had never been written. Quote, "If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsels or your arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may posterity forget that you were our countrymen." Samuel Adams. Section 2. Give me liberty or give me death. Patrick Henry shocked. Young Christian attorney Patrick Henry saw why a jury of peers is so vital to freedom. It was March 1775 when he rode into the small town of Culpeper, Virginia. He was totally shocked by what he saw. There in the middle of the town square was a minister tied to a whipping post, his back laid bare and bloody with the bones of his ribs showing. He had been scourged mercilessly like Jesus, with whips laced with metal. Patrick Henry is quoted as saying, quote, "When they stopped beating him, I could see the bones of his rib cage. I turned to someone and asked what the man had done to deserve such a beating as this. Scourged for not taking a license. The reply given him was that the man being scourged was a minister who refused to take a license. He was one of 12 who were locked in jail because they refused to take a license. A license often becomes an arbitrary control by government that makes a crime out of what ordinarily would not be a crime. It turns a right into a privilege. 3 days later, they scourged him to death. This was the incident which sparked Christian attorney Patrick Henry to write the famous words which later became the rallying cry of the Revolution. Quote, "What is that gentleman wish? What would they have? Is life so dear, or peace so sweet, as to be purchased at the price of chains and slavery? Forbid it, Almighty God! I know not what course others may take, but as for me, give me liberty or give me death!" Later, he made this part of his famous speech at St. John's Episcopal Church in Richmond, Virginia. Jury of Peers. Our forefathers felt that in order to have justice, it is obvious that a jury of peers must be people who actually know the defendant. How else would they be able to judge motive and intent? Peers of the defendant, like the rights of the jury, have also been severely tarnished. Originally, it meant people of equals in station and rank. In parentheses, Black's Law Dictionary, 1910. Freeholders of a neighborhood, in parentheses, Bouvier's, 1886. Or a companion, a fellow, an associate, in parentheses, Webster's, 1828. Who has a right to sit on a jury? Patrick Henry, along with others, was deeply concerned as to who has a right to sit on a jury. Listen to our forefathers' wisdom on the subject of peers. Mr. Henry. By the Bill of Rights of England, a subject has a right to a trial by his peers. What is meant by his peers? Those who reside near him, his neighbors, and who are well acquainted with his character and situation in life. Patrick Henry, in parentheses, Eliot, The Debates in the Several State Conventions on the Adoption of the Federal Constitution. 3:579. Patrick Henry also knew that originally the jury of peers was designed as a protection for neighbors from outside governmental oppression. Henry states the following, quote, "Why do we love this trial by jury? Because it prevents the hand of oppression from cutting you off. This gives me comfort, that as long as I have existence, my neighbors will protect me." In parentheses, Eliot, 3:545, 546. Mr. Holmes, from Massachusetts, argued strenuously that for justice to prevail, the case must be heard in the vicinity where the fact was committed by a jury of peers. A jury of the peers would, from their local situation, have an opportunity to form a judgment of the character of the person charged with the crime, and also to judge of the credibility of the witnesses. In parentheses, Eliot, 2:110. Quote, "The people are the masters of both Congress and courts, not to overthrow the Constitution, but to overthrow the men who pervert it." Abraham Lincoln. Mr. Wilson. Mr. Wilson, signer of the unanimous Declaration, who also later became a Supreme Court justice, stressed the importance of the jurors knowing personally both the defendant and the witnesses. Where jurors can be acquainted with the characters of the parties and the witnesses, where the whole cause can be brought within their knowledge and their view, I know no mode of investigation equal to that by a trial by jury. They hear everything that is alleged. They not only hear the words, but they see and mark the features of the countenance. They can judge of weight due to such testimony. And moreover, it is a cheap and expeditious manner of distributing justice. There is another advantage annexed to the trial by jury. The jurors may indeed return a mistaken or ill-founded verdict, but their errors cannot be systematical. In parentheses, Eliot, 2:516. Freedom for William Penn. Quote, "Those people who are not governed by God will be ruled by tyrants." William Penn. Edward Bushell and 3 fellow jurors learned this lesson well. They refused to bow to the court. They believed in the absolute power of the jury, though their 8 companions cowered to the court. The 4 jurors spent 9 weeks of torture in prison, often without food or water, soaked with urine, smeared with feces, barely able to stand, and even threatened with fines, yet they would not give in to the judge. Edward Bushell said, quote, "My liberty is not for sale." Though he had great wealth and commanded an international shipping enterprise, these bumbleheads, so the court thought, proved the power of the people was stronger than any power of government. They emerged total victors. The First Amendment. The year was 1670, and the case Bushell sat on was that of William Penn, who was on trial for a violation of the Conventicle Act. This was an elaborate act which made the Church of England the only legal church. The act was struck down by their not guilty vote. Freedom of religion was established. It became part of the English Bill of Rights, and later it became the First Amendment to the U.S. Constitution. In addition, the right to peaceful assembly was founded, freedom of speech, and also habeas corpus. The first such writ of habeas corpus ever issued by the Court of Common Pleas was used to free Edward Bushell. Later, this trial gave birth to the concept of freedom of the press. Had Bushell and his colleagues yielded to the guilty verdict sought by the judge and prosecutor, William Penn most likely would have been executed, as he clearly broke the law. He broke the law. Then there would have been no Liberty Bell, no Independence Hall, no city of Philadelphia, no state called Pennsylvania, for young William Penn, founder of Pennsylvania and leader of the Quakers, was on trial for his life. His alleged crime was preaching and teaching a different view of the Bible than that of the Church of England. This appears innocent today, but then one could be executed for such actions. He believed in freedom of religion, freedom of speech, and the right to peaceful assembly. He had broken the government's law, but he had injured no one. Those four heroic jurors knew that only when actual injury to someone's person or property takes place is there a real crime. No law is broken when no injury can be shown. Thus, there can be no loss of termination of rights unless actual damage is proven. Many impostor laws were repealed as a result of this case. It is almost unfair. This trial made such an impact that every colony but one established a jury as the first liberty to maintain all other liberties. It was felt that the liberties of people could never be wholly lost as long as the jury remained strong and independent, and that unjust laws and statutes could not stand when confronted by conscientious jurors. Jurors today face an avalanche of impostor laws. Jurors not only still have the power and the right, but also the duty to nullify bad laws by voting not guilty. At first glance, it appears that it is almost unfair, the power jurors have over government, but necessary when considering the historical track record of oppression that governments have wielded over private citizens. Jefferson's warnings. In 1789, Thomas Jefferson warned that the judiciary, if given too much power, might ruin our republic and destroy our rights. The new Constitution has secured these, in parentheses, individual rights, in the executive and legislative departments, but not in the judiciary. It should have established trials by the people themselves, that is to say, by jury. The judiciary of the United States is the subtle corpse of sappers and miners constantly working underground to undermine the foundations of our confederated fabric, in parentheses 1820. The federal judiciary, an irresponsible body, in parentheses for impeachment, is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped from the states, and the government of all be consolidated into one. When all government, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become as venal and oppressive as the government from which we separated. 1821. Quote, the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislative and executive also in their spheres, would make the judiciary a despotic branch. Quote, judges should be withdrawn from the bench whose erroneous biases are leading us to dissolution. It may, indeed, injure them in fame or fortune, but it saves the Republic. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term be elected as follows. Each state shall appoint, in such manner as the legislator thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority, and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. But in choosing the President, the vote shall be taken by states, the representatives from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there shall remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. In case of the removal of the President from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly, until the disability be removed, or a President shall be elected. The President shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States, or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation, quote, I do solemnly swear, in parentheses, or affirm, that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. End quote. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power, by and with the advice and consent of the Senate, to make treaties, provide 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate, by granting commissions which shall expire at the end of their next session. Section 3. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for, and conviction of, treason, bribery, or other high crimes and misdemeanors. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The judicial power shall extend all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such expectations and under such regulations as the Congress shall make. The trial of all crimes, excepting cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress made by law have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless, on the testimony of two witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Section 3. New states may be admitted by Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parts of states, without the consent of the legislators of the states concerned as well as of the Congress. The Congress shall have power to dispose of and make all needed rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state. Section 4. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and, on application of the legislator, or of the executive, in parentheses, when the legislator cannot be convened, against domestic violence. Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislators of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes, as part of this Constitution, when ratified by the legislators of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses and the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same, done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and of the independence of the United States of America the 12th, in witness whereof we have hereunto subscribed our names. George Washington, President and Deputy from Virginia. In convention, Monday, September 17th, 1787, present, the states of New Hampshire, Massachusetts, Connecticut, Mr. Hamilton from New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Resolved, that the preceding Constitution be laid before the United States in Congress assembled, and that it is the opinion of this Convention that it should afterwards be submitted to a Convention of Delegates, chosen in each state by the people thereof, under the recommendation of its legislator, for their assent and ratification, and that each convention assenting to and ratifying the same should give notice thereof to the United States in Congress assembled. Resolved, that it is the opinion of this convention that as soon as the conventions of 9 states shall have ratified this Constitution, the United States in Congress assembled should fix a day on which electors should be appointed by the states which shall have ratified the same, and a day on which the electors should assemble to vote for the President, and the time and place for commencing proceedings under this Constitution, that after such publication the electors should be appointed, and the senators and representatives elected, that the electors should meet on the day fixed for the election of the President, and should transmit their votes certified, signed, sealed, and directed, as the Constitution requires, to the Secretary of the United States in Congress assembled, that the senators and representatives should convene at the time and place assigned, that the senators should appoint a President of the Senate, for the sole purpose of receiving, opening, and counting the votes for President, and that after he shall be chosen, the Congress, together with the President, should without delay proceed to execute this Constitution by the unanimous order of the Convention, George Washington, President, William Jackson, Secretary. The Bill of Rights. As provided in the first 10 amendments to the Constitution of the United States, effective December 15th, 1791. Articles in addition to an amendment of the Constitution of the United States of America, proposed by Congress and ratified by the legislators of the several states, pursuant to the 5th article of the original Constitution. Preamble. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Article 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Article 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Article 3. No soldier shall, in the time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Article 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Article 5. No person shall be held to answer for a capital or otherwise infamous crime, unless under presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Article 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Article 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Article 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Article 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Article 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Article 11. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Article 12. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit, sealed, to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, and such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest numbers, not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president. If such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Article 13, Section 1. Neither slavery nor involuntary servitude except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Article 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress or elector of President and Vice President, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. Article 15, Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Article 16. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Article 17. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislators. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislator of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislator may direct. This amendment shall not be so construed as to affect the election or terms of any senator chosen before it becomes valid as part of the Constitution. Article 18, Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress in the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of the several states, as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress. Article 19. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. Article 20, Section 1. The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January of the year in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall have not been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified, and the Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. Section 4. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a President whenever the right of choice shall have developed upon them, and for the case of the death of any of the persons from whom the Senate may choose a Vice President whenever the right of choice shall have devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of 3/4 of the several states within 7 years from the date of its submission. Article 21, Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Article 22, Section 1. No person shall be elected to the office of the President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of the President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. Article 23. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered, for the purposes of the election of President and Vice President, to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Article 24, Section 1. The right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for senators or representatives in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Article 24, Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take the office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress within 21 days after receipt of the later written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. Article 26, Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Article 27. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Quote, the poorest man may, in his cottage, bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England may not enter. All his force dares not cross the threshold of the ruined tenement. End quote. This neglected warning was sounded by William Pitt before the British House of Commons, addressing the need for privacy, the protection of life, liberty, and happiness. Will it again go unheeded? Proclaim liberty. Inscribed on our hallowed Liberty Bell are these words, proclaim liberty throughout all the land until all the inhabitants thereof. Leviticus 25:10. Government is not reason. It is not eloquence. It is force. Like fire, it is a dangerous servant and a fearful master. George Washington. Woe to those who decree unjust statutes and to those who continually record unjust decisions, to deprive the needy of justice and to rob the poor of my people of their rights. Isaiah chapter 10, verse 1 through 2. Taking the plunge. My people are destroyed for a lack of knowledge. Hosea chapter 4, verse 6. The only thing necessary for evil to triumph is for good men to do nothing. Edmund Burke, 1729 through 1797. If my people, which are called by my name, shall humble themselves and pray and seek my face and turn from their wicked ways, then will I hear from heaven, and I will forgive their sin, and I will heal their land. 2 Chronicles chapter 7, verse 14. We must obey God rather than men. Acts chapter 5, verse 29. Warning: this document may be hazardous to bad laws. Courts may not welcome or approve of these truths, neither are they to be construed as legal advice. Therefore, to act on these facts is to do so at your own risk or opportunity. I reserve all rights reserved, delegated by God and protected by the Constitution, recognized under UCC 1-308 without prejudice. UCC 1-103.6. Any actions commenced against this content may be in violation of USC Title 18, Part 1, Chapter 13, 241 and 242. Conspiracy to go against my rights under color of law and deprivation of rights under color of law. Please note that you have been informed. If you enjoyed this content, please hit the thumbs up and subscribe and share to your friends that you feel worthy to deem so. God bless you.